Okay, we have 1 more minute, then we'll start. Let's see, we have about 10 people who have come in too. That's the 6 of us. Okay. Hello and welcome everyone to the Disability Right Defenders Network webinar, Enil and Eli's first webinar. I think there's 10 attendees so far, and there's 6 of us who will be active sharing with you on this webinar. Welcome. There should be up to 27, but we'll see when people drop in. I always find this difficult because you feel like you're talking to yourself, but I know I'm not. I'll start with why the welcome and then how the webinar works. Everybody's on mute, but if you want to ask a question during the time in the presentations, you can write a question or raise your hand and we'll see that and then unmute you so that you'll be able to speak. If you have a problem, you can also send a message to us, the organizers. And at the end of this, we'll share a link to the recording so that everybody knows that this is being recorded. Next slide. As I said, the organizers are the European Network on Independent Living and the Independent Living Institute, which is located in Stockholm. On the agenda, we have myself who am speaking now. I'm welcoming you, but then there'll be also Adolf Ratzka, who will speak first, even though in this slide you see he's further down, who will present the Disability Rights Defenders Network. And then after that, Ola Linder, a lawyer from the Independent Living Institute, will talk about the project using the law as a tool, as well as concepts that are important. Siilsalu will present the association. And then we have Eugenia Runeberg from DHR, who will present a Swedish case on accessible transport. And from there, I will hand the word over to you, Adolf.
Now ready? You ready? Okay.
Yes.
Just a moment.
I forgot to put my webcam on to show people when I was speaking, which I can do now. And then you can turn yours and it makes it a little bit more lively, I guess, to see somebody. And you can turn yours on and I'll turn mine off.
Yeah.
Out.
All right. Oh, God again. Can you see me?
No, you disappeared. Now you're coming back.
Oops.
For some reason it goes off.
Well, in any
There
case,
you are.
I'm Adolf Ratzka, speaking to you from the comfort of my office at home in Stockholm. Good afternoon, everybody. And maybe that's enough for you to see me. So the reception will be very shut down. Yeah, we've been in this business for a while, and we know that the situation is still bad as disabled persons with disabilities. We are still second or third class citizens, I would say, despite all the nice papers and documents we have. We have the European Convention on Human Rights from 1950, I believe. It's been around for quite a while. in most countries, as I understand, this has become part of the national law and is a very powerful instrument, I'm assured by my lawyer friends, and legally binding. And of course, for about a decade or so, we have the United Nations Convention on the Rights of Persons with Disabilities. A very beautiful document, phrased in the language of independent living, enshrines our rights, just perfect, protects us from discrimination. But what has changed since we've got these papers? I would say that not many people know about these rights. Not all the lawyers, not all the judges. How about ourselves? Do we know our rights as they're enshrined in those documents? And then the other question is, how many of us do believe that as soon as the law is in place, everything will be just fine and things will change automatically to the better? No, that's not the way it works out. That's when the real work actually begins. Because we got to use our rights. We got to claim them. We got to go out, and if we don't get them, we have to fight for them. And how do we fight for them? Well, the different ways. We've been fighting for them in the streets, and that is fine, necessary to demonstrate our strength. We've been fighting with them by lobbying with politicians, snuggling up to them. That's also fine and useful. But I would like to see that we take the struggle also from the street into the courtrooms. Demonstrations and lobbying may be okay and necessary, but we do have to move the struggle from the streets into the courtrooms. And for this, we need to learn how to use the law and the courts as a tool for changing society to the better. But I'd say that, at least here in Sweden, we are still bloody amateurs. We don't do this so often. We haven't been thinking about these possibilities for that long. So last year, around this time, I started the Disability Rights Defenders Network for the purpose of learning from each other, learning together with each other, pool our resources, pool our knowledge, and become a powerful force that moves our positions forward. So last year in May, we launched the Disability Rights Defenders Network homepage on Facebook. And since then, we've come out with quarterly newsletters that summarize these discussions that we've had on Facebook. And what do we have there? We have court cases, which we comment and analyze. We have news about upcoming events where we can get more training and exchange experiences. We like to provide ourselves with all the information that we can get a hold of, learning about each other's legislation, successes and failures, and strategies. Now, you may not remember that, but in the 60s, Chairman Mao used to say, power comes from the barrel of a gun. He was wrong, of course. I'd say power comes from being able to calmly say, see you in court, fella. Okay, that's all for me right now. Thank you.
Thank you very much, Adolf. After you, we have Ola, who will present different concepts. Please, Ola. You can present yourself more if you would like to. Thank you. Go ahead. We don't hear you.
Oh, we don't hear you.
Can you hear me now?
Yeah, we can. Now we hear you. Very good. Thank you.
Okay, good. Thank you. No, I will very briefly just say that I work with the Independent Living Institute as a lawyer, and it is a pleasure to work with you, Adolf, and everybody else on these issues of using the law as a tool, seeing how different forces of society comes together to create a better direction and social change. That's something that really appealed to me when I first got in contact with the Independent Living Institute and the Independent Living Movement. It is not just to accept laws or current policy, but rather come up with new ideas for policy and actually using the law as a tool. So I will continue by discussing a little bit about something I've noticed recently is that we have in Sweden an organization called Disability Rights Sweden. And that is good and all. Now the question is, what do we mean by rights? Is there anything in particular we mean, or is it just a fancy name? Now we can have human rights. We talk about civil, political, and on the other hand, economic, social, and cultural rights. And they have a bit of a different status, but still they're rights. We can have laws like the LSS law in Sweden, which is usually talked about as a rights law, which grants certain services to people with disabilities, which is not, of course, a very unique thing, but nonetheless, it's usually held that way in the political context of Sweden. You can have regional laws. We should not forget that it's not just individuals that can have laws or rights. Corporations can have them, other entities can have them. There are definitely private rights. And the question is, how do we use them? And to me, something that is central is enforceability. You can't have rights that you cannot enforce. You can't just have a document that says people have rights to this and that without having systems for implementation, procedural safeguards, different legal systems, remedies, and so on. And this, I suppose, is partially a bit of a background to where we are today, seeing as the project law as a tool preceded the Disability Rights Network, the Disability Rights Defenders Network. And it came from the understanding which Adolf mentioned, that laws don't implement themselves. Once you have laws, they have to be used. Otherwise, they give no effect, really. So this is a very important thing when it comes to our work with the project. That was a starting point that, okay, now we have some new changes in the Discrimination Act, especially. It was a procedure that civil society and especially the DPOs and disabled people's organizations of Sweden were advocating for a change in the Discrimination Act to have lacking accessibility as a form of discrimination, which was a long fight, by the way. It was not easy. But then finally the politicians took this idea and enacted it through the national parliament. So we had a law now classifying inaccessibility or lacking accessibility as a form of discrimination. So that was good. And then the real work started. So the project was applied for to the Inheritance Fund so that the Independent Living Institute could use the law as a tool and not just have it seen pass by and implement itself, which it doesn't. Now, an issue was that the Inheritance Fund didn't allow us to take cases to court for the money we were granted. So that's why we have the association, which Mari will talk about a little bit more later on, which then is the platform from which we do litigation. We don't do it directly from the Independent Living Institute. So the project was more or less focused on different ways on information, education, content creation, rather than litigation. And you mentioned, Adolf, that knowledge of rights is a very important feature before you can have social change. And then I tend to agree with that. We could see that once we started having legal advice in the project, we had quite a lot of phone calls and emails coming in asking about, what about my rights here? Have they been violated? What are they? Where is the protection? How can I go about enforcing my rights? So we could quite quickly see the practical need, even after the project started, for having some kind of function in society from where you can actually get legal advice, where you can get knowledge about how you go about using the law and your rights to enforce them, to change a problem, or sometimes even get compensation for violations of your rights. Now, this is something quite important too, that we noticed quite quickly, that you need to start looking into what is the person that's calling wanting. What does the person want? Is it to solve a problem, or is it to have the rights, have the principle, or is it to gain compensation for a grave violation? And this is something that's not always easy to differentiate between, but it's still something that I think is important to investigate early on, in order to then be able to apply the law on that case. Because I don't know what it's like in the other countries necessarily that are listening now today, but in Sweden, if your rights have been violated, the main redress is compensation. Now, we need to understand that it's quite easy to understand that compensation will not fix any violation. It is one form of remedy and redress, but it will not fix, let's say, a grave problem with accessibility to public services. Compensation is not going to change that automatically. So the idea is that through having high compensations, you will force actors to act and remove barriers under the threat of having to pay a lot of money. Now, this may not be the most efficient of remedies at all times, but it is what we have. So that's what we're using here. And this is something I really see as a very important aspect of what this network could do, is to have discussions on what remedies exist, how are they used within the different legal orders, so that we also here in Sweden can use that knowledge to pressure the politicians to institute new remedies, if there are good examples. One thing we did early on in the project was to have some American lawyers come over from the US and talk about how they work with accessibility and disability discrimination. There, they called it disability rights advocates. And they were talking about something quite interesting, which we don't have here. It's a remedy which is called equitable relief. And I would very much like to see that here in Sweden too, to have that system implemented, because it's quite genius actually. What you can do is you can sue some organization or company or state-owned corporation, or even the state itself, or city for that matter, to have a specific measure taken. Let's say, for example, that you build a new structure, and for some reason it was built so that it excludes people with certain disabilities. Now, what you would do is you would sue them for equitable relief, which means that the person responsible for the venture is now can then be held responsible to change the infrastructure and to make changes to the accessibility. Now, that's nothing we have here. You can only sue for damages, which is sometimes a problem with PR, but that's more of a procedural and moral point. But that's what we have to use. Our authorities for enforcement, they are not reliable. We did a study in terms of how do the municipalities work with removing existing barriers. And it was quite clear that they don't really, most of them don't really do that despite the demands in the law. And that leads us to the conclusion that it's not enough to have a law saying this is what certain actors or authorities have to do. It's important to have systems to enforce that obligation. And it's not always fun to say, you know, we have to use some remedies and pressure in that way. But the harsh reality is that if we don't use pressure, then we're not going to see change. Something the project was focused on was then to use this knowledge to identify the limits and the opportunities of the Swedish legal system. And we created especially a book, which unfortunately is only in Swedish, on how the law protects people with disabilities from discrimination, and then how it can be used practically in the court system. So that was a very important part of the project, and we started calling it after a while, which was the result of a cooperation with the Raoul Wallenberg Institute of Human Rights, public legal education. Now, this differs a bit from what many people call human rights education, which is, you know, education on what are the rights on paper, whereas public legal education is more focused on, okay, so what do we do with these rights? How do we practically enforce them? Some other questions that we have been discussing quite a lot is, what does it then mean when we have this system? We have laws against discrimination, and we have certain systems for implementation and safeguarding those rights. But if they're not enough, what do we have then? Well, we have a problem with access to justice is one thing, because not all people can access these legal proceedings that the state has implemented. One major problem in the Swedish situation is the risk of costs. Now, it's not only quite expensive to buy legal services from law firms, but if you lose a discrimination case, if you sue somebody, then you might risk having to pay the winning party's legal fees. And there's no limit for how much that can be. So I know for a fact that many people are deterred from claiming their rights in court because of this loser pays system. Now, we know also that it doesn't have to be this way. There are systems for legal security and legal aid, but they are not easy to access in this field. And you also have a risk of paying at least parts of the money that you incur if you lose. So in practice, we have very few cases in court in Sweden because of how the procedural law is created. So what you have, I remember I was talking to some professor in procedural law. Now, I can hear myself echoing. If somebody can turn off the speaker.
They're speaking. Let's
okay,
see
you
who's
can.
on there.
No. Okay, I'll try anyway. Yeah, right. So a reason for this is that the Discrimination Act or the discrimination law that we have comes from a perspective that the individual has rights. And quite a big part of the law comes from the EU directives quite directly. It's easy to trace how the Discrimination Act in Sweden is reflected in the directives from 2000, especially. The work-life directive that protects many grounds, including disability, and then also the race directive, looking at the different areas of society in which discrimination should be prohibited. So on that side of the law, in the discrimination side of things, you have a strong individual rights perspective that an individual should not be discriminated against, and there should be remedies. Now, this has been pretty much just placed into the the legal system in Sweden as a whole. You haven't really looked over the other parts, and then you have a clash with the civil suit system. the civil law system, where you have, in general, the right to claim something in court, but then it means it has the basic idea that there are two equal parties in these proceedings, like two companies or two organizations or something, where you have an equality of arms. So then it makes sense to have the loser pays system. But for discrimination cases, it's not really the same. Then you have usually a quite strong party, let's say a state authority or a large corporation, or even small ones. And then on the other side, you have an individual whose rights may have been violated. So then you don't really have the same equality of arms principle. This is something that also would be interesting to look deeper into within this network, is to see and compare how the different systems work in terms of having access to justice and being able to actually claim your rights. Now, I have also heard about a very interesting book which I can recommend. It's called the UN Convention on the Rights of Persons with Disabilities in Practice, a comparative analysis of the role of the courts. It was edited by Lisa Waddington and Anna Lawson. And this book is, to some extent, an attempt to try to get into parts of these discussions that we're having now on how does international law become implemented in countries on this level. How can you as an individual claim your international human rights in a national context, looking at access to justice issues and how do rights actually work out once the convention in there, and then interacting with the national systems. It's a very interesting book, and it's a global outreach, but it has some European countries too, so it would be interesting to actually look at this book and then look at other European countries to have a better overview of what's going on in Europe and learning even more. Now, I know that there is power in international cooperation exchange. One very good example, I think, is the European Court of Human Rights and its database for jurisprudence. It's quite easy to search for things there, and in that way you can have a lot of inspiration for how to find good arguments, how to find good cases, because on this international level we have the same body of law, which then can be exported to other countries, even though the case doesn't necessarily concern mine or your country, but somebody else's country. But then when I do search for disability discrimination in this court database, there isn't that much. So I'm starting to think perhaps there is need also on this level to use the law as a tool. There is perhaps need for international exchange to actually not just discuss cases, but to prioritize cases. Which are the priorities in many countries? Are there systemic issues that is not just relevant here, but maybe in our neighboring or quite far away country within the Council of Europe? And I know that ENIL has had these discussions before, and they're still ongoing to some extent, but I think that this network could also have an important role in strengthening that type of exchange. And I was thinking to mention something about strategic litigation too in this context. And what I mean when I say strategic litigation, I suppose many of you have an idea, but something that usually is the case when we discuss the concept is to do litigation, to take a case to court with the goal of having social change beyond the scope of the actual case, to have impact beyond this specific court proceeding. And what you have to do is to, of course, find a good case which has potential to be won. You also have to have some kind of message that can be used, not just a principle on a very strict level, but actually I think, societal level too, that makes a difference in people's lives. So you need to find these quite hot cases. Something that I know is done in the inter-American system of human rights is to really mobilize people. People are mobilizing and having manifestations outside of the court systems when something is going on. So that's something we can learn from to really use civil society pressure in a broader sense than just finding the case. Something that we do is to use the media too, to raise awareness on the case and the pressure, both journalists to write about it, or maybe just make them interested in doing it. Because I've noticed that once you take a case to court, then you get media coverage. You don't get it by complaining over something, but once you sue somebody, media is there. And writing debate articles is also a good way to raise awareness about the issue. But this is where it gets strategic, I guess. Once you have sued, you've done the media coverage, raised awareness, and then let's say you win the case. That's great. But what then? Let's say you win, you get the money, you get the clarification that this and that was indeed discrimination or a violation of rights. Then you need to use that precedent. You need to use the case and keep on pressuring society to change. And this is a huge task. But I think this is where it gets really interesting, when you have the law and the litigation process interact with a political movement-based type of process for social change. So that's how you can reap the fruits of the judgment, for example. I know that there are many European organizations, even in the disability field, doing this. For example, Validity and others. So it would be very interesting to keep this discussion alive in the network. Now, I was thinking I should mention one ongoing case really briefly regarding strategic litigation as a way that we've found that we can use the law as a tool, which is concerning inclusive school systems and how people or pupils with dyslexia are not excluded directly, but they're taking away their reading aids at the national tests, which leads to quite a lot of stress, worry. They become less confident in school, get lower grades. Some of them are then bullied and so on. So this has some quite severe effects on their lives and rights. The Dyslexia Association of Sweden has been pushing for this to have a change of this practice for a long time, using politics and social or pressure lobbying. But this hasn't changed. The authorities, they stand fast. They must believe that it's some kind of prestige principle they have to uphold, that once they've started, they have to keep going, despite there being no real reason for this order. So we talked to the DPO, the Dyslexia Association. We used them to call for families that have been experiencing this. So now we have sued 3 different municipalities, and we have the first main hearing soon, actually this week. So hopefully, once hopefully the court rules that this is indeed discrimination, this is indeed unlawful, then perhaps we can use this precedent, this judgment, then to have a much broader change in terms of having the whole country basically follow the new case law. So that's all for me, I think. Do we have any questions, or should we take them later if there are any?
Thank you. I'm thinking we could take questions both to yourself as well as to Adolf, if somebody would like to have one. I'm trying to find my webcam, but here it is. Okay. If anybody would have any questions to Adolf or to Ola, thank you both for the introduction, both to the network as well as to the project using the law as a tool that Ely has had. It finished in February, was quite successful. No questions. I don't see anybody raising a hand or putting a question there. If not, we'll go ahead and let Mari explain about the actual association which developed alongside with the project using the law as a tool here in Sweden. So Mari, please. Don't hear you, Mari. Let's see.
Yes, hello. Sorry,
Now we
I
hear you.
forgot
Good.
to unmute my microphone. So here I am. Thank you for the word. Yes, the association using law as a tool, as the previous speakers have been saying, this was the association, the organization created with the aim of establishing and strengthening the disability rights litigation culture in Sweden, which is still pretty much absent. And since the speakers before me have been discussing quite thoroughly the different problems and issues and controversies that we have around our work in strategic litigation in Sweden, I will talk more practically how the association in practice carries out its daily work, how we practically do this and try to solve some of these problems that have been discussed. So our work can be divided into three branches, so to say. The first thing we do, we spark discussion and get people to meet. We organize thematic seminars, and last year about the same time we had a big international conference on strategic litigation to bring people together, both lawyers and people who are disabled with and without legal qualifications, to discuss and learn from each other how and what we should do. Another branch in our work is sharing information. As Ola already told, we try to publish in media our successes and what kind of issues we have. As well, we have the Law as a Tool newsletter and the book on anti-discrimination law in Sweden. And also we have done some study films to explain what the anti-discrimination law exactly is and how it works. And of course, the third branch, the actual litigation. The two main issues with our litigation work is we have to find good cases. We have more cases coming in than what we can take on. So we have to kind of choose wisely. And another thing that Ola already touched upon is reducing the economic risks to our members, to the litigants, so they don't lose economically by bringing their case to the courts. That is a very important thing for us to be able to reassure them that they are not going to have to pay money to bring their case to the court. So how it in practice works to bring a case to the court through law as a tool is, first, one has to become our member. Then we have an online reporting service for discrimination cases, which people can use to let us know what has happened. There you go online, you fill in a form with different questions, so we get the details of the case. As well, we actually publish the cases that come through this reporting service, so they become visible. And an important part of fighting discrimination is to make it as visible as possible. Since we can't take on all the cases, we make sure at least the world knows about them. And also through this reporting service, the case goes directly to this Swedish Discrimination Ombudsman. And before we move any further with it, we actually wait for the answer from from Swedish Discrimination Ombudsman and see whether the person already gets help from there. If the person does not get help from Discrimination Ombudsman, then we, since we have to choose wisely, we start the evaluation work of the case. So we have a very good cooperation with law students who have been, who then find out, for example, whether the facts of the case are evidenced well enough, so that we are able to bring enough evidence in court to win. Or we also need to answer a question that whether that legal precedent that comes out from that case would make life better for a bigger amount of disabled people in Sweden. Because when it makes life better for only one person, so to say, that's unfortunately not really good enough for us. We need more than that. We need legal precedent that will bring about bigger change. Once we have done the evaluation work, then the board of using the law as a tool organization decides whether the case should be brought to the court or not. If so, then we have a network of lawyers who can work pro bono, do their work for free, and support the litigant, the person whose case will be brought into the court. And then, in order to reduce the economic risks, we have something that's called process fund, where we have collected money which comes from the membership fees of the organization, as well as if when we win in the court, then half of the monetary compensation that the litigant gets goes also in the process fund. So we have gathered amount of money, so when there are some costs in the litigation process, then those will be paid from the process fund. That way, on year 2018, there were around 10 cases evaluated. Six of them were brought to the court. We have around 30 members in our organization and about 13 support members. Now I was thinking I can use one of the cases that have been brought under the using law as a tool, so you can see more practically how it works. The case I'm using is Sofia Toresdottir's case, who has been active after the case very much in media as well. Her articles and things are mostly in Swedish though, but the ones who can speak Swedish can read quite a lot about her own reflections about how it felt for her to bring her case to the court. So what happened in Sofia Toresdottir's case was that she had been constantly already complaining to the authorities, because when she was riding the bus in her city, there was no audio announcing of the stops. She did not know which bus stops were going by. And she had been complaining about that and had been ignored. So she came to using law as a tool for help, and we hoped her to bring her case to the court. And in the court procedures, she then sued the public transport company as well as the city authority responsible for organizing public transport. And towards the end of the process, they decided to pay a monetary compensation to Sofia. So the monetary compensation was paid out. But what Sophia also reflects about is that there is still today no accessible public transport for her. The audio announcement for bus stops does still not work. She reflects upon that. Of course, there is a power in the court decision itself, that it's a legal confirmation of her rights that have been violated, and that is powerful. But it still wasn't quite enough to get the accessibility to work. So we still have some work left there. One role of our organization is, if we get enough of these kind of cases like Sophia's case, then we can raise awareness and of the society that is so used to violating disabled people's rights that we don't even notice that it's happening. But through this kind of legal confirmations that these rights have been violated, we can at least wake the society up and let them know that this is not quite right. But then, of course, once we have these legal precedents warm from the oven coming out, then we have to have a strategy. How do we work with them further so we actually do get accessible public transport and accessible everything that we need in the society? Thank you.
Thank you, Mari. Let's see, are there any questions now? I don't know if everybody's aware, you can write, if the hand's not working, you can actually write the question in the box, on the question box, and then we can unmute you as a participant so that you can speak. If there's no questions for Mari, we'll go on to Eugenia from DHR. She will explain who DHR is, the organization, and the case that they had on accessible transport. So thank you very much, Mari, and welcome, Eugenia. Yeah, you're up. We don't hear you though. Let's see, I need to unmute you just a second. I think I muted everybody when we had the problem with Ola's mic there. Unmute you, Eugenia. Now you're unmuted, so please go ahead.
Thank you. Hello, my name is Eugenia Runeberg and I'm a lawyer at DHR. I will turn the camera off though, if that's okay. So DHR is an organization that works for the rights of people with disabilities. And for the first time in the history of DHR, we have taken a matter to court. And this was the case of inadequate accessibility as discrimination. So now in Sweden, a person can be discriminated on the basis of inadequate accessibility, which means that a person with disability is disadvantaged through failure to take reasonable accessibility measures in order to put people with disability in a situation comparable to that of people without such disability. So the background to this is that before the form of discrimination, inadequate accessibility, was in place, there was a ministry memorandum called Beyond Fair Words, Inadequate Accessibility as Discrimination that investigated the matter of this inadequate accessibility as discrimination. So eventually the memorandum was made public and was sent on referral, which is normally done to different organizations, authorities, and so on, so they can state their opinion. But after this referral was sent out, and eventually the time was up to answer it, nothing happened. No proposal referred to the Council on Legislation for consideration, nothing at all. So this was in 2010, I can add. And at that point, DHR decided to take action and initiated what was called the Thursday manifestation. So this meant that people from all parts of the Swedish disability movement stood outside the government office every Thursday morning when department ministers went to their weekly meetings at 8 o'clock in the morning. So people were standing up until 9 o'clock. So other organizations joined this manifestation, such as, for example, the organization that represents disabled children and youth, amongst many other organizations. And initially, the department ministers, well, initially they saw the people standing there as a threat, but then eventually they started to come up and talk. And this actually went on from 2011 to 2014. So also at that time, DHR had discussions with the Confederation of Swedish Enterprise, in Swedish Svenskt Näringsliv, which is Swedish largest and most influential business federation representing 49 organizations. And they actually thought that companies in Sweden, because of this law, would go bankrupt. And obviously that hasn't happened. And also some politicians comment this in a very strange manner, like saying, why should all pharmacies be accessible when you can find an accessible pharmacy close by? So obviously a lot of people lacked of understanding regarding this. And also the president of DHR said something very wise that says, if you have a business idea that requires that you have to discriminate somebody to make your business profitable, then it's a bad business idea. So, however, in 2015, discrimination in the form of inadequate accessibility for people with disabilities was prohibited by law. So, why did we take on this case? We wanted to test the law when it came. And we had a member, Lars-Göran. He was going to visit his brother in a different city, but he couldn't enter the bus to take him there because the bus driver didn't know how to. The bus driver didn't have the proper training in how to use the stair lift. And as this happened, Lars-Göran, the member, reported this to the Equality Ombudsman. This is the government agency that works on behalf of Swedish Parliament and government to promote equal rights and opportunities and to combat discrimination. So he was hoping that they would take on this. But the answer they gave him to this complaint was that it could be discrimination what happened. They don't know for sure, but they are not going to take this matter further. And so it was a very vague answer. So this DHR then decided to take this to court. And some non-profit associations have the right to litigate in place of an individual. And this is regard to the size of the non-profit association, the financial status, the knowledge, and so on. So there has to be a few things in place. But we did. And the court then initially had to decide on the responsibility. If in fact Lars-Göran was discriminated, should it be the region of Gävleborg or the bus company that traffics the bus line? Who was in fact responsible if this was considered discrimination? So this particular matter was decided in the Supreme Court, and it was ruled that the region was responsible in the case of discrimination. So the issue of discrimination, the matter was then decided in the district court. And we won the case, and the region of Gävleborg in Sweden had to pay 16,000 kronor, crowns, this is the Swedish currency, to Lars-Göran because of the inadequate accessibility that he wasn't able to enter the bus. And so what happened at the time of the discrimination, it was that Lars-Göran, he recorded this event. So it was obvious to the court, because this was used as evidence, that the bus driver didn't in fact have the proper training to manage the lift, which made it inadequate accessibility. as Lars-Göran depended on the stairlift and couldn't take the bus. And also a fact in the matter was that the bus driver offered to carry Lars-Göran onto the bus, but this wouldn't change anything. And Lars-Göran said, no, thank you. But however, this wouldn't change anything in the eyes of the law, because nobody has have to be put through something that could be interpreted as humiliating as this. So also in this case, the bus driver didn't make sure that Lars-Göran got another bus ride to replace the bus trip. So the court reasoned that the region was in fact guilty of inadequate accessibility, and in the case also the bus driver didn't take enough action to make sure that Lars-Göran then could use the replacement fare, which would have, in this case, have been a taxi not paid by him, Lars-Göran, in this case. So the compensation for this discrimination is made to cover the violation because of inadequate accessibility. And the compensation is determined based on the severity of the violation, amongst other things. So a violation is considered more severe if the consequence of the violation is more severe. And such consequence can be not having the possibility to go to work or study. This is just an example. So in this case, the court reasoned that the fact that Lars-Göran couldn't use the bus didn't cause any serious loss or risk of a serious loss for Lars-Göran, let's say losing his job. Furthermore, there was nothing that pointed to this inclination from the region through being less accommodating towards people with disabilities. And also compared to discrimination in general, this case was not, according to the court, not as serious compared to what is usually considered as discrimination. Furthermore, Lars-Göran hasn't expressed that he felt seriously violated, and there were also no circumstances of a mere serious nature that reinforces the event. So therefore, the region of Gävleborg had to pay 16,000 Swedish crowns to Lars-Göran as compensation. So since then, we haven't taken on other cases, but we have discussed the matter. So we'll see what happens in the future. And what we do as of today now is that we talk about this case, we talk about discrimination, how it works to our members, and also we have information on the website to help, and a checklist that members can use to see if there wasn't a discrimination in certain cases. They can see if a certain case was in fact discrimination. So that's what we do now in this matter. Thank you.
Thank you very much. That was interesting, even for me who've heard it a few times.
Thank you.
Find my camera here. Thank you. I had a few questions myself, but I'll give a chance. Is there anybody in the audience who would like to ask a question? Okay, we saw something. No questions for now. And then somebody said, question. Will the audio or the video recording be made available later on? And if so, can you make the info available somewhere, including to persons who have registered? Unfortunately, I have to go again. Thank you so much. As I already wrote about Yuka from Belgium. And the answer to that, I don't know if he's still here, would be that yes, we'll make it available. I don't think he's there, but we'll get in touch with him. Okay, my questions are, what I found interesting, Eugenia, was one, the need of empowerment to understand that being carried is a humiliation, because many times that's what people offer. They offer to carry you. I remember being in Tanzania when the Swedish embassy was brand new with CEDA, and the embassy had their offices and it wasn't accessible. There was no elevator. They forgot to build it, even though there was legislation they should. And of course they offered to carry me. Okay, I had no choice if I wanted to be there, which I wanted to, but I wrote an article and complained afterwards, which made them very, very angry. How could you, we carried you, but that's humiliating.
Yes,
so
yes.
The humiliation, but then also the arbitrariness of how do you understand when something is severe enough, for who decides what's severe and what's not severe. And also a replacement of another bus. Maybe you have to wait another hour. How do they look at that time compensation for your time?
They didn't mention anything about that, but they mentioned the fact that he wasn't, because the region, they have the service that there should be a replacement fare, but in this case he didn't get one, and they reasoned that this adds up to how they interpreted the situation.
Okay,
So it's
'cause I'm
a fact, but they didn't elaborate that specific
like
question.
you don't know if they would offer you one in an hour, should you accept that, or how that would work. And then the other thing, when you talked about evidence, and in this case filming, what other kind of evidence is there to do that people should think about or be aware about?
Well, I mean, to record the event, because in Sweden you can, it's okay to record something if you're in the recording. So if you can record what's happened as you're in this recording, voice recording, you should do that and use that as evidence, as Lars, because he was filming, but he wasn't actually filming the people. He was filming, but basically it was a recording of what was said. So that's what he did. But yeah, use record to have some evidence. That's really important.
Should somebody think about having a witness, or not necessarily?
If there is a witness, that also adds as evidence. So of course that's really good. So a witness, or and also on your cell phone, it's really easy to record a conversation or an event. So I think that's a good idea.
Okay, and then you talked about your checklist. I haven't looked at that myself, so I'm thinking we could look at it and maybe see if that could be put into English and then shared with the network, for example.
Yes, of course.
Okay, does anybody else have any questions for Eugenia? And otherwise, does anybody would you want to say anything about evidence, or?
Adolf has a question.
Adolf has a question, okay.
Adolf.
Just a minute, I'm gonna go to the speakers now and unmute them so that they can speak. Unmute Adolf. Very good, okay, Adolf.
Okay, my question to Eugenia would be, I'd be interested to know what have been the consequences, the repercussions of this court case, or actually the two court cases. What do we know about how widely the industry, the transportation industry, was informed about the court case? Do we know anything about whether companies took measures to make sure that they complied to the obligations to which they were for which they were responsible according to the court case? That would be interesting to know.
As I understand, sorry.
Has DHR done any of such searching?
We haven't checked. We haven't looked into this. In my understanding, there was going to be, but we haven't actually followed it up. But we should. That's a good question.
Yeah.
Any other questions from anybody else?
I can mention something about.
Go ahead, Ola.
Yeah, regarding the case that Mari mentioned in the collective transportation in region Örebro. Now, we have another person who is eager to sue again because of the issues that are still remaining regarding the inaccessibility. So this is something we need to consider now, whether we can have the force to do it again and to maybe push it not just to a friendly settlement, but to an actual judgment, and in that way increase the pressure, because now we have the money, and actually the company admitted wrongdoing too, which was good. They admitted that they hadn't done enough. But then now the question is, can we sue again, or how do we increase the pressure to use the legal system with its limitations and possibilities to actually push for for the social change we need. So that's another tip, I suppose. That's another idea, is to mobilize more people to do this, and not just having one person in each county or within the same system, but rather mobilizing many people to increase the pressure and the, perhaps, if I may say so, the relevance of the case, at least in the eyes of the media and the courts.
In a way, that's also one of the goals of this network, this Defender Rights Disability Network, on growing as a network, sharing the experience and being able to mobilize and grow in numbers to be able to use the law as a tool to even make change. Any other questions from anybody? Like we said, this book, he said that he speaks Swedish. The one Yuko who had to leave us, he can read that, which is good. When it comes to the Facebook group, sorry, go ahead, Camille.
There is a question from Mari.
Mari, okay.
Yes, I would like to, in terms of mobilizing more people to bring their cases, I would like to have Ola and Eugenia reflect over, would you want to take it as far as bringing a class action, or what, to reflect a little bit over the perspective of bringing class action in disability rights?
Ola, can you
start
speak on that?
Okay. I think that the class action option could be useful in certain contexts. When it comes to something like this, you would have to weigh the pros and the cons, not just looking at the positive side of having increased pressure, but also the risks that come with it. Because there, at least here, I don't know what it's like in other countries, but here it's a special form of litigation, and it includes the obligation to have a special kind of attorney, an advocate, who has taken the bar exam, and they can work for free, but they generally don't. And then you would probably have to mobilize money in a different way. It's also connected to quite big risks in terms of having to pay the winning party's fees if you lose. At the same time, if you win, you can have full compensation for your legal costs. So that's a plus if you have a strong case. One plus side too, compared to litigating alone, is that if you do a class action, then you have many people sharing the risk. So it's not as riskful in that sense in terms of monetary. If you lose, you don't have to pay as much per person. So it's a good thing to look for. So I think it definitely has merit, and you would have to look in a concrete situation. What are the pros? What are the cons? Do we need this extra force, or and connected with the risk, or can we do it as a normal civil suit with one person or association?
I agree with Ola, but also you have to find people for this class action, which, how do you find, obviously there are cases, but how do you find people who are willing to do this and see this through? And that's an issue too.
That brings me to the question of time, because doesn't a lot of these things take a lot of time? And how do I know at the European Court, they say that sometimes before the case is actually tried, the people could have died before they get their case tried.
Hello?
Adolf, yeah?
Yeah, short comment. We hear a lot about class action in the US, where it's a very effective and popular and cost-effective solution. But I understand that there's a big difference between the US system And for example, the Swedish system. In the US, it's a lot easier to define the class. And lots of people can join that would not be able to join in Sweden. So finding these people in Sweden is much more difficult than it would be in the US. So they've had a lot of success with the particular definition of class action, and using class action the way it's allowed in Sweden does not yield the same effects, unfortunately. Okay.
Thank you. Any other comments or questions?
I have a question, probably to Ola or to Eugenia.
Go ahead,
Yes.
Tamil.
And the question is, this project using the Ratzka tool is very interesting, and as far as I understand, it's based on Swedish law and Swedish on Sweden. What would you suggest to be the first steps to do it in different countries? I am living in Greece. Other people are here today in our audience, I don't know, from Italy, from Belgium, from different parts of the world. What would be the first steps you suggest so we can implement something similar?
Adolf, do you want to answer that?
Yes, if I may. Well, the very first step would be to join the network on Facebook and come your questions and your concerns and invite other members to respond to them. Because Greece is in just about the same situation as everybody else in Europe. We are amateurs. We have to basically start from scratch. And we can help by pooling our resources, as I said earlier. So please join the Facebook discussion.
Okay, thank you. We will join.
I saw today that there was a message. One of the Suella, who's one of our participants today, is actually asked to join. When people ask, what's the process there? Maybe you could say that so they know, Adolf.
Yeah. Well, we asked, can you see me? Can you hear?
We can hear you, but we can't see you. Then we can see you and hear you.
We ask people when applying, it's a closed session, it's a closed group. So we ask people to please present themselves by answering a few questions. And the reason, the rationale for these questions is that we'd like to know who are our members, so we can draw on their knowledge and experience. And that would be very useful. But I noticed that not everybody get the message. Not everybody answers these questions. So please make sure that you do answer these questions. They're useful for the rest of us.
So when they become a member of the Facebook, do they automatically then get the newsletter, or how does that work with the newsletter and the, what do you call it, the prenumeration, what do you call it, the subscription or whatever?
Well, it's independent from each other. So you can get the newspaper in any case, the newsletter.
How do you apply for that?
Well, you just send us your email address, that's all.
Send the email address to yourself or through the Facebook, or I'm just wondering myself. I haven't actually done so yet.
To the Facebook.
To the Facebook, okay.
Can I say something to the question from Greece?
Yes, Ola, go ahead.
Yeah, I don't know what work you're doing. I don't know what the needs are. So it's something I would pretty much try to define before starting something like this. Define the purpose of such project. Would it be implementing a specific law? Would it be implementing discrimination perspective or disability perspective, disability rights perspective? What would the target group be? How would you approach them? Because in the end, what I think one of the main results of the project was to actually connect the knowledge of rights to the practical tools for how to actually use them in courts strategically and so on. And that's how you get the effect. You don't really have a big effect just talking about rights, but you need to connect it to the practicalities and the limitations within the Greek legal system, which I know nothing about. Perhaps drawing a bit from European law is something to not underestimate. I don't know what the situation is in Greece regarding the disability rights directives and conventions.
Should I answer that?
Yes, please go ahead, come in.
Well, yeah, to be honest, I'm not an expert on the laws and all these things but yeah, as far as I know, the situation is far from Swedish model. And yeah, a lot of the CRPDs implemented only partially. For example, we don't have any independent living, not even legislation. So things like that, not only for CRPD, but also for the elections now, not everyone will be able to vote. And a lot of rights are violated, from simple rights like discrimination with transport and stuff like that, like the ones mentioned before, to more important ones like we have institutions, we don't have many different independent living, nothing about it. So yeah, I think it will be not that easy to implement exactly the model of Sweden, at least not very soon. But yeah, it's good to learn that something like that exists in other places, and we can start to do something similar. And yes, try to push from our sides.
Adolf?
If I may comment this, well, I don't think that sounds so horrible in a situation as you try to explain it, because you still can go to the courts. You still can mobilize allies within the legal community, law students, law professors, human rights lawyers. You have them too in Greece. Just look for them. You haven't maybe looked enough. Of course, disabled people are not sexy. I mean, there are a lot of other groups, minorities, that get more interest, attention from the legal community than we do. But it'll come, it'll come. So don't give up. It's the same here in Sweden. We have to work to get to these lawyers, to get to know them. And you can already now use a couple of tools that you have. For example, when it comes to public transportation, the directive on buses and coaches from the European Union has to be incorporated into national law and has to be immediately translated into national law. And that we have had for at least 10 or 12 years. So if you find a bus that's not accessible, you can, with probably good success, sue the government, local government, for not complying to the European Union directive on buses and coaches. That's just one example, and I'm sure you'll find more.
Thank you. Indeed, indeed, the way you present it, it's possible. So we will look for that. Thanks.
Okay, anybody else? No more questions being written. I have a couple of comments. I mean, one, this was an introductory webinar, and then we're thinking of having one, maybe two on sharing experience, depending on who would actually sign up and what kind of, we'll go out with some through the Facebook, people who would like to sign up to be able to speak about their experience. And then the third one or fourth one would be on future development for the network. I'm thinking also after this webinar, it would be interesting for us for suggestions on what should have been better, or is there something, for example, we didn't go in so much to concepts as we could have. Are there concepts that you would like to have explained? You can write that when you get an opportunity, I think, through the webinar, that there's some sort of an evaluation. And if not, you can always contact myself or Ina through Ina and give us your both your criticism so that we can be better at this and meet the needs of how would we like to see this develop? That's just a bit of a question or some comments. Like I said, I thought it was interesting with this, the arbitrariness of, what's severity, and I don't know if there's anything written on empowerment and actually development in this area. Would you know that, Adolf?
No, not offhand.
Maybe this book that you talked about, Ola. What was the name of that again?
Yeah, could you repeat the name?
Sorry, which one?
This book you spoke about from Lisa Waddington and Ann Larson. What was the name of that again?
Oh, yes, of course. Yes, it's called the UN Convention on the Rights of Persons with Disabilities in Practice, a comparative analysis of the role of courts.
Okay, that's more the role of the courts, but that could be interesting.
No, but what's interesting in this one is that it looks not just at the courts, but actually it ties into a fairly new discipline of law, which is called comparative international law, which is groundbreaking not just within disability rights, but within international law as a discipline in itself. It's maybe not the first book to bring it up, but it's one of the most extensive ones and one of the first ones at least, because it looks at how international law interacts with the national legal system. And that's something that's not really been done that much in the same way. And that's also where the courts come in. How do the courts view international law, and how does it implement it? Does it give people rights or not, and how this dynamic works? It's very interesting.
Okay. So any more questions? It says raise your hand, but I don't actually see this hand raising. But maybe that's I see it now. You look at it in the participants there. Now I see where it is. If nothing else, I mean, we said we would go on to 1900, but if there's no more questions, or would anybody of the speakers like to say something else before we end? Any conclusive remark? We've gone through the network and the development and how important it is to share our experience, that we're learning in this together. We talked about the actual project that Sweden had that could be copied, as you're interested in, Camille. The association which developed from the project, which is now just changed to a new board, and I think it seems to be a promising association. We'll know more with time. And then your example, Eugenia with DHR, thank you very much for presenting that. And like I say, I mean, I know that case took you some time, because it took some time before they decided who was the one that was responsible. How long was the total time on that, Eugenia?
I'm sorry, I don't know, because when I started, it was somewhere in the middle, so I'm not sure actually when it started.
Maybe 3-4 years. I don't know if you would know, Ola.
Yeah, the case was, I mean, the circumstances of the case occurred on January 2nd of 2015, meaning the day after the law entered into force, classifying lacking accessibility as a form of discrimination. And remind me, was it that you had the court judgment last year in June, if I remember right?
2018, 11th of June, yeah.
Which means it took over 3 years. But, I mean, they first used the Equality Ombudsman. It took about a year. Then DHR sued. And then it took, I don't want to say a full year, but almost a full year to get the response from the Supreme Court as to whether they had sued the right party or not. Because there was the issue of, is the region the right one, or is it the bus company that provides the service de facto on the ground? who can be held responsible under what circumstances. So that's also a very good outcome from the case, which we didn't mention. It wasn't just the fact that it was classified as discrimination, but also in the field of services to the public. You know that under certain circumstances, even though you have procurements and different company structures, a different company than the one actually providing it can be held responsible, especially if it looks like it's another company from the outside. So that's a good case outcome, because it's valid in different areas too, not just collective transportation and disability.
Okay. Now you see there's no quick fix, but it's important with this mobilization, which I think everybody's coming from different countries, that it's important to try to mobilize within your own country. I think within the association, there's both lawyers, there's people from the representing or coming that are themselves active in different disability organizations, and other people that are interested in the subject. But who else do you think are, Adolf, maybe on your side, who else would you suggest to try to get on board if you're moving to try to build up a network within your own country? Lawyers and students and disabled people.
Yeah, I'm here. Yeah, can you hear me?
We can hear you, yeah?
Yeah. Well, that's quite a lot of people already. Human rights lawyers, students of law, the professors, instructors, researchers, disability organizations, of course. The problem there is that still in Europe, most of our organizations are deeply embedded in the medical model of disability, where it's the individual that's the problem bearer, and the solution is looked at in the individual. So if you can't get on the bus, maybe you need an operation instead of a ramp. So that's still a problem we're facing in many places. But
Okay,
you have enough of allies if you look around, because it's obvious you cannot get on the bus. I mean, look at where we are. In the 1950s, in the US, in the southern states, Black people had to get in the back of the bus. In the 90s and the 20s, and now still in Europe, in many places, disabled people can't even get on the bus. We are still way back. We are still second and third class citizens. And people usually grasp this if you tell them it that way. Can't get on the bus.
70 years later.
Can't get on the bus to go to work. Can't get on the bus to go for education. I mean, they realize that if you tell them in those words, it's outrageous.
When you think it's 70 years ago as well, my gosh, yes. Okay. Otherwise, I see no more questions coming from the group. I'll just thank everybody very much for coming. Thank you guys for speaking. Adolf, Ola, Eugenia, Mari. And again, please be in touch and join the Facebook group if you haven't already to get the newsletter, and send us ideas on things, how you would like to see this develop. And with that, if nobody else has anything to say, I'll close the webinar. Okie dokie. Bye, everybody.
Bye.
Bye-bye.
Bye.
Bye-bye.